There are divorces that don't start with love dying. They start with power getting cruel. A husband walks into court backed by money lawyers and confidence, while his wife is forced to stand alone because he made sure she couldn't afford anyone. Then he laughs and says loud enough for everyone to agree, "You're too poor to hire a lawyer." People like to believe the truth always wins. But Americans also say, when someone shows you who they are, believe them the first time. So when a man turns the courtroom into a stage to erase her, does she swallow the humiliation and sign whatever keeps the peace? Or does she stand up and speak one sentence that can freeze the entire room? Before we dive into today's story, let us know where you're tuning in from. It's always amazing to see where our stories travel. Don't forget to subscribe so you won't miss the next twist in this journey. Now, I'd like to invite you to listen to her confession. My name is Nix Arden. I'm 34 years old and I stood alone in courtroom 3C of the Maricopa County Superior Court because my husband made sure I had no other choice. I wasn't there to prove a point about independence. I wasn't there to make some dramatic stand. I was representing myself because Grant Halden had systematically stripped away every financial lever I could have used to hire a lawyer. By the time our case reached the docket in Phoenix, I had no retainer, no credit line, and no safety net left to lean on. I chose my outfit carefully that morning. A simple, slightly worn navy dress, low heels, no statement jewelry. I carried a thin leather folder and a yellow legal pad instead of a polished trial binder. I wanted to look exactly how they expected me to look, overwhelmed, underprepared, and outmatched. Across the aisle, Grant looked like he was walking into a board meeting, not a divorce hearing. His attorney, Pierce Welling, had a thick binder tabbed in neat precision. A paralegal sat beside him with a laptop open and color-coded notes. Grant had a glass of water, not the plastic cups, stacked near the clerk's desk. Everything about their table said, "Structure, control, confidence." Everything about mine said, "Gamble." I didn't end up representing myself out of pride. It was a design. First, the joint account was frozen. I found out at a pharmacy counter when my card declined while I was picking up a prescription I'd been on since the miscarriage. Then my credit card was canceled due to suspicious activity. My login credentials for our shared cloud services stopped working overnight. Passwords changed, access revoked. Even small contingency funds money I had tucked away years earlier became unreachable. When I called attorneys, the answer was polite but consistent retainer required. 5 figures, up front. Grant, meanwhile, was still the CEO of Halden Route and Freight, a logistics empire running freight lines across the Southwest. He could afford to stretch this case for months. I couldn't afford week 1. So when my name was called and I stood up and told the court I would be appearing pro se, the room shifted. Grant leaned back in his chair and laughed. Not a quiet chuckle, not something private, a full audible laugh. "She's too poor to hire a lawyer," he said loud enough that it reached the back row. There were small reactions, someone clearing their throat to hide a laugh, someone else looking down at their phone too quickly. It wasn't open cruelty. It was worse. It was agreement. Judge Lorraine Beckett didn't smile, but she looked tired, the kind of tired that comes from seeing the same outcome 100 times before it even begins. I could read it in her posture, another emotional wife, another powerful husband, another predictable ending. Pierce didn't waste time. He stepped forward and began framing me before I could speak. He described me as deeply emotional, financially uninvolved in the company, and struggling to accept the reality of the marriage's end. The message was clear. I was clinging. I didn't understand numbers. I was reacting. I let him talk. I didn't come to court for sympathy. I didn't come to recite my sacrifices or remind anyone how many late nights I spent supporting Grant's rise. I came for one reason: to put the truth on the record in a way that couldn't be brushed aside as a meltdown. I knew if I came in swinging with everything at once, Pierce would bury it in procedural objections and drag me through technicalities until I was exhausted and discredited. I needed precision. I needed timing. So when it was my turn, I stood without theatrics. In the respondent's financial disclosures, I said evenly, "There is a material omission. A non-revocable trust structure called Coyote Star Trust with an estimated value of approximately $47 million. The room stopped, not because of the number alone, because of the language. That wasn't the vocabulary of a hysterical spouse. That was the language of someone who understood disclosure obligations. Judge Beckett's head tilted slightly. "Do you have evidence of this, Ms. Arden?" "Yes, Your Honor." I walked forward and handed the clerk a single document. Exhibit 1, a wire confirmation, transaction ID, date, amount in the millions, destination account that did not appear anywhere in the financial disclosures submitted by Grant's team. Pierce didn't object immediately. That was the tell. Grant's smile disappeared, but I saw something else in his face. Not fear, calculation. He still believed he could win, not by disproving the trust, by discrediting me. As the hearing adjourned for the day, I didn't push further. I didn't unveil the rest. I let them believe I had gotten lucky with one document, because I knew what was coming next. They wouldn't attack the trust. They would attack me. The hallway outside courtroom 3C felt different after that first session. Conversations were lower, quick, strategic. I watched Pierce lean in close to Grant near the elevators. His voice was rapid, controlled, not panicked, just recalculating. Grant, who had walked in with the easy confidence of a man expecting to sign papers and leave, was suddenly quiet, not angry, just processing. He looked like someone who had seen something that wasn't supposed to exist. By the time I reached the parking garage, my phone buzzed with notifications, missed calls from unknown numbers, one voicemail from a private investigator Pierce had likely hired before I even left the building. I already knew the shift they were about to make. They wouldn't deny Coyote Star Trust existed. They would question how I found it. The next morning, Pierce executed that plan perfectly. Before I could raise anything further, he addressed the court. "Your Honor, the respondent has reason to believe Ms. Arden obtained corporate documents through unlawful access. We are concerned about potential unauthorized intrusion into protected company systems." He didn't need to prove it. He just needed to suggest it. If the judge believed I had acquired the evidence improperly, the content wouldn't matter. The trust could exist. The transfers could be real. But the evidence would be tainted, excluded, and I would be reframed not as a victim, but as a saboteur. He layered it carefully. The company's systems are secure. Access is restricted. If documents were accessed outside authorized parameters, that raises serious concerns. He never said the word hack. He didn't need to, because hack would sit in the room all on its own. I felt the shift in the courtroom again. Not laughter this time, suspicion. I had prepared for that. Months earlier, when Grant first began consolidating everything into what he proudly called our family sync server, I hadn't thought much of it. He loved efficiency, loved control disguised as convenience. He insisted every device in the house sync automatically photos, calendars, scans of passports, digital copies of contracts, even exports from certain work files so he could review things at home. The server sat in our basement, blinking quietly in a metal cabinet like some harmless appliance. But convenience is a crack, because in his need to control access to everything Grant made, one mistake, he centralized it. Some of his corporate export files reports, summaries, transaction overviews automatically mirrored to the family system. Not because I hacked anything, not because I bypassed firewalls, because he said it that way. When Pierce implied unlawful access, I didn't argue emotionally. I didn't protest outrage. I simply stated, the documents I referenced were accessed through a household storage system to which I had lawful access as a co-occupant of the residence. Judge Beckett didn't respond immediately. She noted it. Pierce changed direction again. That's when he introduced Dr. Evelina Crowhurst. He submitted a sworn affidavit describing me as experiencing paranoid ideation, emotional instability, and referencing a prior inpatient treatment following the loss of our child. Grant leaned into the performance. Soft voice, concerned tone. "I'm worried she's relapsing," he said. "I've tried to protect her privacy. Protect me from myself." That was the strategy. If I was labeled unstable, then everything I presented could be dismissed as projection. I didn't flinch. When I took the stand, I acknowledged the truth. I had suffered a miscarriage. I had experienced severe depression. I had difficulty sleeping. I sought treatment. I was hospitalized briefly. If I denied it, they would expose it. But I drew a line. I was treated for grief, insomnia, and depression, I said calmly. Not for paranoia, not for delusions. Pierce tried to corner me. If I reacted strongly, I would appear volatile. If I cried, unstable. If I stayed calm, manipulative. So I chose brevity. Yes. No. I don't recall that phrasing. He pushed harder. Are you saying a licensed physician falsified her assessment? I'm saying I answered that the description in that affidavit does not reflect my diagnosis. And then I shifted the ground beneath him. I began recording certain conversations I said evenly because I realized my words were being reframed after the fact. The room tightened. Pierce's head snapped up. Objection. I was a participant in those conversations, I continued. Arizona is a one-party consent state. I am legally permitted to record conversations in which I am present. I didn't ask to play the audio. I didn't dramatize it. I asked for procedure. I request that the device be submitted for proper chain of custody and admissibility review. Judge Beckett considered it. Then she nodded. The device will be submitted and sealed pending review. I saw it then. The hesitation in Pierce's posture, the microsecond delay before he sat down. He didn't know what was on that recording, and for the first time since this case began, he wasn't certain it was harmless. As the device was handed to the clerk and sealed, I felt the room shift again. Tomorrow, if that audio was reviewed, the question would no longer be whether I was emotional. It would be whether my husband had broken the law. The morning of the next hearing, courtroom 3C felt different. No one laughed when I walked in. People looked at me longer, not kindly, not warmly, but longer. Curiosity had replaced dismissal. The yellow legal pad was still in my hand. The same dress, the same thin folder. I hadn't upgraded my appearance. I wanted the contrast to remain. Let the evidence carry the weight. Pierce stood when we were called, his posture composed, but slightly tighter than before. Grant didn't look at me at all. He didn't smirk. He didn't whisper. He sat forward, hands clasped, like a man trying not to react too early. Judge Beckett entered and wasted no time. Given the allegations raised, she said evenly, this matter may no longer be limited to a standard division of marital assets. If there is evidence of concealed assets, interference with witnesses, or conduct potentially constituting criminal activity, this court will address it accordingly. That changed everything. Pierce could no longer treat this like an impatient judge eager to close a messy divorce. The scope had widened. The tone shifted from family dispute to procedural scrutiny. Pierce stood and immediately began attacking the audio. Your Honor, communications between spouses are protected in certain contexts. Protected, how Judge Beckett asked, in spirit if not strictly privileged. Additionally, recordings can be edited, manipulated, taken out of context. Playing such material may create unfair prejudice. She didn't accept general fear as an argument. Mr. Welling, I need specific legal grounds. What is your objection? Authenticity chain of custody. Statutory privilege. Pierce recalibrated. Authenticity and potential alteration. I spoke only when addressed. I am requesting that only portions relevant to concealed assets and statements regarding manipulation of medical documentation be considered. No theatrics, no emotional framing, just scope. Judge Beckett allowed a limited review of the recording under procedural guidelines. The clerk retrieved the sealed device. The courtroom felt smaller when the audio began. Grant's voice came through clearly. Not the polished executive tone he used in public. The private one. She's broke. No one's going to take her seriously. A faint scrape of glass in the background. She's got a file nix. A record. All I have to do is remind people of that. Silence in the courtroom. If she touches the trust, I'll bury her. And then the line that altered the atmosphere completely. Crowhurst will write what I need. You think diagnoses are sacred? They're labels. Labels can be arranged. No one spoke for a few seconds after it ended. This wasn't about how I felt anymore. It was about what he had said. Pierce stood quickly. This could be fabricated. I would like to call Dr. Evelina Crowhurst, I said before he could regain control of the rhythm. The courtroom doors opened. Dr. Crowhurst stepped in. She did not look like a confident expert witness. She looked tired, hollow-eyed, the kind of tired that follows weeks of waking up at 3 a.m. with regret. Judge Beckett allowed her to take the stand. I kept my questions narrow. Doctor, you treated me following my miscarriage? Yes. You signed an affidavit describing me as experiencing paranoid ideation. Yes. Did that description reflect your actual diagnosis? Her throat moved before she spoke. No. Pierce rose. Objection! Overruled, Judge Beckett said sharply. Dr. Crowhurst continued. You were treated for grief-related depression and insomnia. There was no clinical basis for a diagnosis of paranoia. Why did you sign the affidavit, I asked? There was a long pause. I was under pressure, and a financial matter involving my practice was resolved. The room absorbed that. Pierce didn't argue further. He sat down. Judge Beckett's tone hardened. This court will note potential interference with medical documentation and possible concealment of assets. These matters may exceed civil implications. Grant shifted in his chair for the first time like someone physically uncomfortable. He had controlled the narrative for years through image and intimidation. Now his own words sat in the transcript. And I wasn't done. As the hearing adjourned for the day, I knew something fundamental had changed. The case was no longer about credibility. It was about exposure. But I still held back the most dangerous pieces, the numbers, and the evidence that would force the court to act immediately. By the next hearing, I understood exactly where Pierce would aim. He could no longer win by painting me unstable. That path had collapsed the moment Dr. Crowhurst admitted the affidavit did not reflect her clinical assessment, so he shifted from attacking my mind to attacking my method. When I arrived early that morning, I watched him in the hallway speaking with Grant in low, clipped sentences. There was no more public swagger, just containment. Inside the courtroom, before I could present anything new, Pierce stood. Your Honor, we need to address the manner in which Ms. Arden accessed corporate data. We believe there may have been unlawful access to proprietary systems. He proposed a series of requests. Limit the scope of financial inquiry. Investigate my conduct as potential unauthorized intrusion. Prohibit me from continuing to use internal company data. Consider sanctions if the court found I was abusing litigation to damage Halden Root and Freight. It was clean, strategic. He wasn't denying the substance. He was asking the court to prioritize procedural safety over uncomfortable truth. To treat me not as a whistleblower, but as a vengeful spouse destabilizing a company. When it was my turn, I didn't argue emotionally. I am not asking this court to investigate a company out of curiosity, I said. I am asking the court to examine information directly related to marital asset disclosure and potential diversion of funds. I requested permission to present a structured financial analysis, not scattered documents, not accusations, numbers. Judge Beckett allowed it. I stepped forward with organized monthly summaries. This is no longer just about my marriage, I began. It concerns money withheld from employee paychecks. I explained the scale of Halden Root and Freight. Thousands of drivers, warehouse staff, dispatch coordinators, many enrolled in a retirement contribution program through payroll deduction. I displayed the first comparison, payroll deductions per month, the reported deposits into the custodial retirement account, then bank confirmations. The discrepancies were consistent, repetitive, patterned. Judge Beckett leaned forward. Where did the difference go? To an offshore account connected to a holding structure not disclosed in marital filings, I answered. Linked to the same network as Coyote Star Trust. Pierce attempted to interrupt. Accounting timing. I showed the timestamps. Transfers occurring within 24 hours of payroll cycles, matching amounts, matching intervals. This is not a rounding error, I said quietly. I added another piece. An internal audit had flagged irregularities. The employee who raised concerns was removed from their role shortly afterward. I didn't ask for sympathy for the employees. I didn't dramatize. I simply let the math sit in the air. Grant lost composure. She stole those files, he snapped. She hacked internal systems. She's trying to destroy the company. Mr. Halden, Judge Beckett warned, maintain decorum. His outburst said more than any rebuttal could have. He wasn't arguing the numbers. He was attacking my right to have them. Judge Beckett's tone shifted again. These allegations involve potential third-party harm and asset dissipation. If substantiated, this court may consider emergency measures. Emergency measures. The words changed the temperature of the room. I didn't present the final piece yet. The booking confirmation, the evidence suggesting imminent departure from jurisdiction. I held it. Because I knew what they would try next. They would attempt to prove I never had lawful access to any of it, and I was ready to show that the very system Grant built to control everything was the same system that made the truth reachable. The next hearing would not be about emotion. It would be about urgency. By the time we returned to courtroom 3C, the gallery was fuller than I had ever seen it. Word travels fast in Phoenix when a CEO is accused of hiding tens of millions and manipulating a medical affidavit. The air felt heavy, like the kind of morning before a monsoon breaks. Pierce stood the moment the judge took her seat. Your Honor, before any further testimony, we request clarification on the scope of this proceeding. He spoke carefully, measured no aggression. It wasn't the tone of a man attacking anymore. It was the tone of a man building a wall. He asked the court to limit jurisdiction strictly to marital dissolution issues. He suggested that any corporate matters be separated into an entirely different hearing. He warned about prejudice if the court continued hearing allegations that extended beyond family law boundaries. On paper, it sounded reasonable. In reality, it was delay. They needed time to move assets, time to reshape the narrative, time to frame me as reckless before the numbers locked them in. I listened without interrupting. When Judge Beckett turned to me, I kept my answer simple. I am not asking this court to investigate a company out of curiosity, I said. I am asking the court to examine evidence directly tied to marital asset disclosure, diversion of funds, and potential dissipation of assets during these proceedings. She nodded slightly. Pierce pivoted again. There remains the issue of how Ms. Arden accessed proprietary data. There it was, the wall. I stood. I did not break into company servers, I said plainly. I did not bypass security. I did not hack any corporate system. I let the words sit. No dramatics. Grant configured our home storage system to automatically sync certain files from his work devices. The documents I referenced were mirrored onto a shared family server located in our home. Judge Beckett leaned forward. Ms. Arden, did you have authorized access to that system? Yes, Your Honor. It was installed in our residence. We both used it daily. It stored our personal photos, tax documents, travel records, and other shared files. Access was not restricted to one spouse. Pierce began to object, but Grant spoke first. That's not how she opened it, he snapped. She used the Nightrail export folder. He stopped. It was a small mistake. One sentence too specific. Judge Beckett's eyes moved slowly to him. Mr. Halden, she said evenly, you appear to know precisely how those files were accessible within the residence. Pierce reached for his arm, but it was too late. Grant had just confirmed that the files existed in a location accessible from home. I didn't need to argue. He had done it. I shifted immediately. I am not asking this court to divide assets today, I said. I am asking this court to preserve them. That word changed the direction of the room. Preserve. I am requesting temporary measures to prevent dissipation and to protect third parties potentially affected by these transfers. I outlined them clearly. Temporary freezing of specific asset groups tied to the holding structure, appointment of a receiver or independent monitor, temporary control of voting interests within the marital asset block to prevent rapid liquidation or restructuring. I kept my voice steady. This is not about punishment. It is about preventing irreversible harm. Pierce tried to reframe it as emotional retaliation, but the numbers from the prior session were already part of the record. Before Judge Beckett could respond, I added one more layer. There is an additional concern regarding potential flight risk. The words drew a reaction. Subtle, but real. Pierce stiffened. Grant's jaw tightened. I will request permission to submit time-sensitive documentation at the next hearing, I continued. Documentation that indicates preparation to leave jurisdiction. I did not elaborate. I did not reveal the booking confirmation yet. But I watched Grant closely. His reaction was not confusion. It was calculation. Judge Beckett looked from me to him. Very well, she said. The next hearing will address emergency preservation measures and any imminent risks. As we exited, I knew the window had narrowed. Grant would not sit still under the pressure much longer. And when pressure meets ego, mistakes happen. The emergency hearing felt less like a divorce proceeding and more like damage control for something larger. Courtroom 3C was full. Not just observers, reporters, staff from the company. A few faces I recognized from Halden Route and freight operations. Word had spread beyond family law circles. Pierce entered without the confident stride he once carried. He was composed, but guarded. Grant looked thinner somehow, tense, restless. When we were called, I didn't waste time. Your Honor, I began. I would like to summarize the pattern currently on record. I listed each point deliberately. Concealed asset structure under Coyote Star Trust, dual reporting accounting system known internally as Night Rail, shell payments linked to an entity associated with Sloan Merritt, a medical affidavit admitted under pressure and not reflective of clinical reality, payroll deductions diverted from employee retirement contributions to offshore accounts. I paused. In civil proceedings, the court does not require absolute certainty to act. It requires sufficient grounds to prevent imminent harm. Judge Beckett nodded once. This court is aware. I reached into my folder and placed a new document on the clerk's desk. This is a booking confirmation for an international flight departing Phoenix tonight. The room shifted instantly. The timestamp was printed clearly. The booking occurred during the recess of the prior hearing. The source file metadata showed synchronization through the home storage system. Grant stood abruptly. That's fabricated, he said. She manipulated that. But then he made the same mistake twice. She couldn't have seen that unless she accessed my travel app directly, he said. It was in the synced folder on Pierce grabbed his sleeve. Judge Beckett's expression hardened. Mr. Halden, you have now twice confirmed the presence of synchronized files within the residence. Grant said nothing. I continued calmly. I am requesting immediate surrender of passport prohibition on departure from the state freezing of assets connected to the holding structure and formal appointment of a receiver to oversee financial activity. I met the judge's eyes. This is not retaliation. This is protection for employees whose retirement funds are implicated and for assets under this court's jurisdiction. Before Judge Beckett could speak, the courtroom doors opened. 2 investigators entered. They approached the bench first, then turned toward Grant. A warrant was read. Charges under review included fraud, embezzlement, laundering of diverted funds, and interference with sworn medical documentation. The words landed like physical weight. Pierce stood slowly. Your Honor, I will need a copy of the warrant and request immediate counsel access for my client. He had shifted roles instantly. No longer architect of the narrative, now damage containment. Grant did not argue. He didn't perform. He didn't look at me. He looked like someone calculating escape routes and finding none. Judge Beckett addressed the room. This matter is no longer limited to marital dissolution. Emergency preservation orders will be issued immediately. As Grant was escorted out, I felt something unexpected. Not triumph, not relief, something heavier. The truth had broken through, but truth alone does not stabilize chaos. As the courtroom emptied, I understood that this was only the beginning of a far more volatile phase. When secrets surface, systems shake. And now I was standing at the center of it, not as a victim, not as a hero, but as the only person in that room who knew exactly how much more was still buried. The door had opened. Now I had to make sure it didn't close again under the weight of panic and power. When the courtroom doors closed behind Grant and the investigators, the noise didn't stop. It just changed. The hallway outside courtroom 3C was chaos. Reporters were already gathering near the elevators. Phones were raised. Microphones appeared as if they had been waiting all along. My own phone wouldn't stop vibrating unknown numbers messages from former colleagues, alerts from financial news sites. I stepped into the corridor and realized something uncomfortable. Winning inside a courtroom is not the same as stabilizing what breaks when the doors open. There was no rush of triumph in me, no sense of victory. What I felt was weight, because Grant's arrest wasn't the end of something. It was the beginning of collapse. And collapse never lands cleanly. It crushes sideways. It takes down people who had no seat in the courtroom. In the clerk's office, I was handed the emergency order bearing the judge's signature and seal. It was detailed and precise. Grant's passport was to be surrendered immediately. Travel restrictions were active. Specific asset categories connected to the holding structures were frozen pending review. A receiver would be appointed to oversee sensitive financial activity and preserve documentation, and I was granted temporary authority over certain decisions tied to marital voting interests, but only in coordination with the receiver. I didn't receive power. I received responsibility. The order didn't elevate me. It placed me between a falling structure and the ground beneath it. By mid-afternoon, I was standing in the lobby of Halden Root and Freight headquarters in Phoenix. The news was playing on every mounted screen. CEO arrested during divorce hearing. The ticker crawled with speculation. Inside the building, employees clustered in tight groups. Some stared at their phones. Others looked up at me as I passed through the lobby, not with hostility, but with uncertainty. The elevators to the executive floor felt like they were carrying me into a pressure chamber. When the doors opened, the boardroom was already full. The receiver's representative sat at the head of the table. Several board members were speaking over each other. Legal counsel from the corporate side was on speakerphone. Credit partners were demanding immediate calls. One major client had already requested assurance that freight routes would not be disrupted. No one opened with moral outrage. They opened with liquidity. We need to consider divesting non-core assets immediately. Freeze expansion projects, transfer certain holdings into separate entities, reduce exposure. I listened long enough to understand the direction. They weren't afraid of me. They were afraid of paper. If they began selling divisions, quickly moving assets across subsidiaries, or restructuring ownership chains under the banner of stability, the documentation trail could fracture. And if that trail fractured the retirement funds, the offshore transfers, the concealed trust connections would dissolve into confusion. I stood and placed the emergency order on the table. "I am not here to take over," I said. Silence. "I am here to execute the court's preservation mandate." I outlined the options: full cooperation with the receiver, maintain operations, provide transparent access to financial systems, protect employee payroll and retirement flows, or proceed with aggressive liquidation attempts and risk immediate escalation to federal task force oversight already reviewing server data. I didn't need them to like me. I needed them to calculate. One board member asked bluntly, "Are you threatening the company I'm describing consequences?" I replied. The room quieted. That was when I began to notice something deeper. During the document review session that followed, the receiver's team began extracting email chains and approval logs tied to the suspicious transfers. Patterns surfaced. The same cluster of executives approving offshore movements. Language deliberately vague in internal memos, phrases like timing adjustments and temporary reallocations. Approval chains that looped through Sloan Merritt. Sloan wasn't just a private betrayal. She was administrative infrastructure. Several consulting payments had passed through an entity bearing her signature authority. As the layers came into focus, it became clear this wasn't a single man improvising greed. It was a system, a network of people who benefited from controlled opacity, which meant they would not simply disappear quietly. They would look for a scapegoat, and I was an easy candidate. That afternoon, I made my first public move. I requested a call with union representatives and senior operations leaders from major freight terminals. On speakerphone, I addressed the retirement fund discrepancies directly. "An independent audit is being initiated," I said. "Priority 1 is restoring proper flow to employee retirement accounts under court supervision." I didn't promise miracles. I promised process. By the end of the call, the tone inside the operations teams had shifted. Not relief, but direction. Outside, the media storm continued. Inside, a fragile line of trust began to form. Late that night, long after most of the executive floor had emptied, I stayed. The building felt hollow, and I knew there was still one piece I hadn't seen yet. Something older, something foundational, something that would explain why this had never just been about divorce. It was close to midnight when I stepped into Grant's former office. The skyline outside the windows was dark. The building was nearly silent except for the low hum of ventilation. Exhaustion sat behind my eyes, but clarity kept me upright. This was the point where evidence disappears if you blink. I walked slowly through the room. The desk drawers were already cataloged, the visible cabinets cleared by the receiver's team. It was the framed landscape on the far wall that caught my attention. It hung slightly uneven. Behind it, recessed into the drywall, was a small steel door. A safe. I didn't touch it alone. I called the receiver's representative back to the building and documented the discovery before opening anything. Chain of custody mattered more now than ever. When the safe was unlocked in the presence of witnesses, its contents were not stacks of cash or jewelry. They were files, an external hard drive, bound ledgers, printed projections, land maps. I recognized one map immediately. It was my family's property outside Phoenix, near a developing freight corridor. My father had held on to that land for decades. It wasn't glamorous, but it sat along a route that had recently become valuable for logistics expansion. Inside the folder were development projections, zoning strategies, notes on acquisition structures, and one line that stopped me cold: secure via marital transfer. My name appeared not in affectionate handwriting, but in bullet points: legal access pathway, asset consolidation, property leverage. I sat down slowly. This had not begun with resentment. It had begun with strategy. Marriage had been an acquisition channel. The control over finances, the medical labeling, the pressure to appear unstable. All of it now aligned with one objective: protect the long-term plan. Further in the documents, I found something else: internal communications discussing contingency responses. If Nix attempts to use internal files, position as unauthorized access. Preempt narrative: unstable spouse attempting to damage company. Engage media relationships. They had prepared for resistance. They had planned to invert it, to paint me not as a whistleblower, but as a criminal. Pierce's early strategy in court suddenly made perfect sense. This wasn't reactive. It was rehearsed. I closed the ledger and handed it to the receiver's team. Every device, every file was logged and sealed. I contacted the lead investigator and notified them of newly discovered materials tied to property strategy and pre-litigation narrative planning. I made one request: protect internal employees willing to cooperate. Preserve all server systems immediately. Do not allow quiet data cleansing. Days later, when the formal divorce filings concluded under supervised restructuring agreements, I didn't walk away wealthy. Most of the asset structures remained under investigation. The retirement funds were placed under monitored restoration plans. Grant faced charges that would unfold in a separate arena. I drove out to my family's land one evening. The desert air was quiet, the sky wide and open. I stood where my father once told me stories about building something steady and honest. I carried a copy of the court's preservation order, not as a trophy, as proof that paper can speak when people try to silence you. I thought about that first day in courtroom 3C, the laughter, the certainty, the way the room had decided who I was before I opened my mouth. And I compared it to the final hearing when silence followed every document entered into record. No one laughed then. This was never about winning. It was about refusing to let someone else define my reality through money labels or fear. I did not leave with power. I left intact. And sometimes that is the only victory that matters. There are moments in life when we realize the real battle was never about money status or even winning. It was about dignity. About whether we allow someone else to rewrite who we are, or whether we quietly stand up and speak for ourselves. Tonight's story is not about revenge. It is about clarity. It reminds us that when everything loud falls away, what remains is character, and character rarely shouts. We all carry wounds that never made it to a courtroom. We all face moments when silence feels easier than truth. But sometimes choosing to speak calmly, steadily changes more than just the outcome. It changes us. And maybe that's the part that matters most. If this story resonated with you, subscribe and stay with us. This channel is simply a space where we sit down, listen, and share what life has taught us. And if you'd like, leave a few lines in the comments about what stood out to you. Your thoughts might be exactly what someone else needed to hear. Thank you for spending this time with us. Take care of your heart, and we'll see you in the next story.